Hello and welcome to BYJU'S Exam Prep IAS. Before we start with our today's analysis, a quick gentle reminder. As part of Target Prelims 2022, our tomorrow's session would be with respect to science and technology, and this will be the first video. Please do tune in from 7:30 to 9:30 p.m. on our YouTube channel. Let's get started and look into the first article. The first article says pardon and remission. Let us try and understand what is this article all about. The Tamil Nadu government back in the year 2018 recommended the release of all 7 convicts in the Rajiv Gandhi assassination case under Article 161 of the Indian Constitution. The Article 161 of the Indian Constitution speaks about the pardoning power of the governor. So we have the Cabinet of Tamil Nadu. The Cabinet of Tamil Nadu had made a recommendation to the governor of Tamil Nadu. But instead of accepting this recommendation, he has referred this to the president. Now we have a question in the Supreme Court. Does the governor have such a power to refer the recommendation given by the cabinet to the president? Let us try and understand what is the broader picture. When we look into the Constitution of India, we have the pardoning powers which is given to the president as well as to the governor. Which are these two important articles? One is what we have is Article 72 of the Indian Constitution, which speaks about the pardoning powers of the president. Then we have Article 161 of the Indian Constitution, which speaks about the pardoning powers of the governor. What are the differences between the pardoning power of the president as well as the governor? When we speak about the pardoning powers, there are different words in this particular article. One, it speaks about pardon. Second, it speaks about suspension. Third, it speaks about remission. And the fourth, it speaks about this commutation. What is commutation? It basically denotes a substitution of one form of punishment with a lighter one. When the judiciary has convicted a particular person, it has imposed a punishment. This punishment will be replaced with a lighter one. That is what is called as commutation. Then we have something called as remission. What is remission? It implies reducing the period of the sentence without changing its character. Let's say, for example, there is a particular person to whom about 10 years of rigorous imprisonment is imposed. So what would happen under remission? The person's character, that is the rigorous imprisonment, will continue to be so, but instead of 10 years, it might be reduced to about 8 years. It can be reduced to about 5 years, depending on what the executive decides. That is what is called as remission. Then what we have is suspension. What is suspension? Basically, it is about withdrawing the sentence for a temporary period. So it is the temporary postponement of the sentence which is called as suspension. Then what we have is the pardon. Pardon basically means if there is a particular person who is convicted by the court of law, this person is absolved of all the charges. So this person who is behind bars will be allowed to free himself and his liberty will be reinstated. These are the different terms that we have under Article 72 as well as Article 161. What is the difference between the powers of the president as well as the governor? When you look into the Bare Act, it says the president shall have the power to grant pardon, reprieve, respite, remission of punishment, or to suspend, remit, or commute the sentence of any person convicted of any offence in all cases where the punishment or sentence is by the court martial. So remember, if there is a punishment given by the court martial, such powers would be only given to the president, and this power is not given to the governor. So if the court martial has imposed a punishment, what is court martial? So those proceedings which are undertaken in the military court. If a person is convicted in the military court, only president will have the power to pardon him, so on and so forth. But this particular power is not given to the governor. This is the first difference. Then it says in all cases where the punishment or sentence is for an offence against any law relating to a matter which the executive power of the union extends to. Which are the powers or which are the laws where the president would be able to pardon, suspend, remit, or commute? We have the union list, we have the concurrent list, we also have the state list. If there is a particular law drafted by the central government with respect to the union list as well as the concurrent list, only in those cases the president would be able to do so. But if it is to do with the state list, it is given to the state state government, which is nothing but the governor. Added to it, when it comes to the concurrent list as well, the governor also has the powers. So when it comes to the union list, the president has the powers. When it comes to the state list, it is the state government, which is nothing but the governor, who has the powers to pardon, remit, so on and so forth. But do remember, when it comes to concurrent list, both the president and the governor would be able to take up that particular case. And in all cases where the sentence is of death, let's say for example a person has been imposed with death penalty. In this particular case, pardon can only be given by the president. This particular power is not given to the governor. The governor cannot pardon a death sentence, and this power is only given to the president. When we look into the clause 2, nothing in subclause of clause 1 shall affect the power conferred by law or any officer of the armed forces of the union to suspend, remit or commute a sentence passed by the court martial. We did discuss about it. And nothing in subclause C of the clause 1 shall affect the power to suspend, remit or commute a sentence of death exercised by the governor of a state under any law for the time being in force. Just because the president has this particular power, this does not mean it is taking away the power of the governor. The governor's power is totally independent. The president's power is totally independent. Each of them would be able to provide these pardon, remission, suspension, commission on their own according to the 7th schedule. So we did discuss that in the union list as well as in the concurrent list, president would be able to absolve all the charges if it is pardon, and he would be able to commute so. And if it is to do with the state list and the concurrent list, the same can be done by the governor on the recommendation or the aid and advice of the cabinet of the state government. Now if you look into article 161, it says the governor of a state shall have the power to grant pardons, reprieves, respites or remissions of the punishment, or to suspend, remit or commute the sentence of any person convicted of any offence against any law relating to a matter to which the executive power of the state extends to. So what is this executive power? So if you are able to make laws in one of a particular area, in such cases the governor would be able to do this pardoning power, or this power is guaranteed to him under article 161. So the extent of executive power is also mentioned under article 162 of the Indian Constitution. So this is what is given under article 72 as well as 161. Now the question is this the only law that speaks about remission and so on? No, we also have a statutory provision as well. What we just discussed is a constitutional paradigm. What we just discussed is mentioned under article 72 of the Indian Constitution as well as 161 of the Indian Constitution. So this is clearly mentioned in the Indian Constitution, but added to the Indian Constitution we also have a statutory law as well, and that is to do with Code of the Criminal Procedure. So when we speak about the Code of the Criminal Procedure, what we have is 3 important sections. So in addition to the Constitution of India, what we have is the CRPC, which is the Code of the Criminal Procedure 1973, and this law also gives the power to the government. When you speak about the Constitution, it gives the power to the president as well as the governor, but when you speak about the statutory provisions, it directly gives the power to the government. What do we mean by it? Under section 432, the appropriate government may suspend or remit a sentence in whole or in part with or without the conditions. What do we mean by appropriate government? It basically means it can be the state government or it can be the central government. So if it is a law drafted under the state government, that is the state list, in that case there is the government which would be able to suspend or remit a sentence. So when we say government, it need not necessarily ask the governor or notify the governor. It need not have to take the permission from the governor. In the earlier cases in 161, what exactly happened? You had the state government, this recommendation was sent to the governor and the governor had to give assent to it as well. In this case, it is the government which decides and it need not have to take the so-called official permission from the governor. That's the basic difference between section 432 as well as the constitutional paradigm of 161. So in this particular case, if the government is releasing, that is suspending or remitting a sentence, it can impose certain criteria. What do we mean by criteria? Let's say a person who is imposed with imprisonment for a term of about 7 years. So if this particular person has to be released, let's say hypothetically, so this person will be given certain conditions that you should not run away from India. There are some conditions that you have to follow. You should not abuse the rule of law. So such conditions will be imposed on this particular person. If he violates that condition, he can be asked to come back to imprisonment. He can be put behind bars once again. So there can be conditions imposed by the state government, or there can be no conditions as well. So government can also not impose any conditions and then release this particular person. So this particular section is under 432 of the CRPC. Under section 433, any sentence may be commuted to a less one by the appropriate government. Appropriate government, once again, it can be the state or the central government. What do we mean by commuted to a lesser one? Let's say, for example, if death sentence is accorded to that particular person. So if death sentence is given, this can be replaced by any other punishment that is present in the Indian Penal Code. So instead of awarding this particular person capital punishment, impose this particular person with any other punishment that is given in the Indian Penal Code. So Indian Penal Code has life imprisonment, Indian Penal Code has 14 years of imprisonment, Indian Penal Code has 20 years of imprisonment, Indian Penal Code has 7 years of imprisonment. So replace this particular death penalty with any of the punishments given in the Indian Penal Code. Then if a person is imposed with imprisonment for life, then such a person can be imposed with an imprisonment not exceeding 14 years or for fine. If there is a particular person where rigorous imprisonment is awarded to that person, in such a case, this rigorous imprisonment can be replaced with simple imprisonment. And if a person has been imposed with simple imprisonment, such person can be imposed with fine as well. So pay the fine and you can leave. So that is what is called as replace, or that is what is called as commute for a lesser one. Where is it present? It is present under section 433 of the CRPC. Then we have section 435, which says that if the prisoner had been sentenced in a case investigated by the CBI or any agency that probed the offence under a central act, the state government can order such release only in consultation with the central government. What do we mean by it? Let me explain this with the help of an example. In this case of Rajiv Gandhi assassination case, so there what was happening, it was a CBI which was actually investigating this case. Additional to the CBI, if there is any central agency, let's say for example we have the NIA, or let's say for example we have the Enforcement Directorate, these are the agencies which report directly to the central government. These are the laws that are made by the parliament. If there is a particular case which is investigated by the central agency like the CBI, NIA or ED, in such a case the state government does not have any power under any of these sections. If the CBI or ED is enforcing it, and if the state governments still want to have commutation or they want to suspend or remit a particular sentence, they always will have to take the permission of the central government. Only if they are able to take the permission of the central government, if the central government gives them the power, only then they would be able to use section 432 as well as 433. If the central government does not give the power, the state governments would not be able to do anything if such a law is under investigation which is drafted by the central government and it is taken care by one of the central authorities like the CBI, Enforcement Directorate, or it can be any other central agency. So if there is a conflict, in that case the state government will have to consult the central government, and only if the central government gives the permission, the state government would be able to initiate these legal procedures under section 432 as well as 433. So what are the differences between the statutory provision and the constitutional provision? Both may look similar, but they are different. One is the constitutional, the other is the statutory. When you speak about the statutory provision, it is the government which directly has the priority. It did not have to consult the governor as well. If the government decides, they would be able to initiate proceedings under section 432 as well as 433. But if it is to do with the constitutional principles, that is article 72 or under article 161, in such case they have to refer it to the governor or the president, and only then they would be able to give the pardoning or the remission. These are the major differences. And now we have one of the landmark judgment with respect to Maruram versus Union of India. According to this landmark judgment, the Supreme Court of India said that section 432 and section 433 are not a manifestation of article 72 and 161, but instead they are separate. Though it looks similar, yes, they are similar, but they are totally different and independent of each other, said Maruram versus the Union of India. Now the question is, what has this got to do with Rajiv Gandhi assassination case? 7 persons were convicted by the Supreme Court in its final verdict in the Rajiv Gandhi assassination case. So those people who are involved in the Rajiv Gandhi assassination case, 7 of them were convicted. Of these, 4, which happens to be Sriharan, Nalini, Perarivalan and Santanan, were given the death penalty. Out of 7, 4 were given the death penalty. 3 others, that is Robert, Jayakumar and Ravichandran, were sentenced to life imprisonment. In the year 2000, the governor commuted the death sentence of Nalini to one of the life imprisonment based on the recommendation of the cabinet. She was initially imposed with death penalty. So what we have is a commutation, which is one of the lighter one. So instead of death penalty, what she got was one of life imprisonment. The remaining 3 remained on death row and their mercy petitions were pending with the president. In 2014, the Supreme Court commuted the sentences of Sriharan, Perarivalan and Santana to life imprisonment. Immediately, the then Chief Minister Jayalalitha decided to remit their sentences. The state government wrote to the centre seeking its opinion within 3 days. It had to do so under section 435 of the CRPC. The state had to consult the centre as it was a case probed by CBI. We did just discuss that under CRPC, yes, it is a statutory provision. It need not have to consult the governor. The government has the own initiative, can release such a person. It would be able to remit, suspend and also. But in this particular case, since this was being investigated by the Central Bureau of Investigation, it had to seek the permission of the central government. But what exactly happens? The central government does not accept. Why? Because it says it is being investigated by the Central Bureau of Investigation and we do not want to release such prisoners. So this ultimately goes to the Supreme Court of India, and the Supreme Court of India looks into this entire controversy and says that since this is being investigated by the Central Bureau of Investigation, the central government has the power to decide it. So it went in favor of the central government. However, it also said this is to do only with the CRPC. So the government would not be able to release them under CRPC, but the government would be able to use Article 161 of the Indian Constitution or Article 72 of the Indian Constitution. So the judgment given by the Supreme Court is only with respect to the CRPC, where the government on its own would be able to take a particular step, but that is not allowed in this case because it is being investigated by the central authority. But you can make use of Article 161 of the Indian Constitution, says the Supreme Court of India. So what does the state government do? In September 2018, the state government decided to invoke Article 161 of the Indian Constitution. So the state government advised the governor that the remainder of the life term of all these 7 convicts be remitted so that they could be released. From the year 2018, this particular initiative has been held by the governor because there is no time period given by the Constitution. And now what we have is this is being referred from the governor to the President of India. So can such a reference be made from the governor to the president is what is this article all about. So basically we have the Supreme Court of India which is looking into this particular controversy, that if a recommendation is made by the cabinet of the state under 161, can the governor refer the same to the president is what is being looked into by the Supreme Court of India. So this entire controversy is about this particular issue. So we will have the Supreme Court which will pass on its observation and judgment in the near future. Once it passes up, we will take it up once again. As of now, this is all you have to understand with respect to this article. Now let's look into the next article. This article says call of port. Let us try and understand what is this article all about. We have the Bangladesh Prime Minister Sheikh Hasina, who has proposed that India's landlocked northeastern region can make use of the Chittagong port to enhance the trade with the region. So she basically says, as of now, when you consider the northeastern part of India, it is landlocked. What do we mean by it? It does not have access to the sea. So we have Sheikh Hasina's government, which goes on to say that making use of the Chittagong port, which is present in Bangladesh, we would be able to enhance on our trade relationship with India and Bangladesh. So she currently goes on to say that the port would be benefiting India's northeastern states, particularly Assam and Tripura. The two other northeastern states bordering Bangladesh include Meghalaya and Mizoram could also benefit from the access. The first important pointer from the preliminary examination point of view is which are the northeastern states which are in borders with Bangladesh. First, what we have is Assam, then what we have is Tripura, we have Meghalaya, we also have Mizoram. Do note we are speaking about the northeastern states. So these are the northeastern states which have a border with Bangladesh. What are we discussing under this article? We are going to discuss about the trade relationship. We are also going to speak about how some of the goods and services can be transferred from India, mainland India, to our northeastern states via Bangladesh. Ultimately, it will help us in transferring all these goods at a minimal prices. Why? That is because if we have to transfer all the goods via the chicken neck, it will be a costly affair. In order to mitigate this, what we can make use of is the Chittagong port in this particular case. So let us try and understand how cost efficiency comes into picture. Prior to 1947, what exactly happened? Prior to 1947, we were making use of the Brahmaputra and the Barak rivers. These rivers were made use of by India, and ultimately all the important goods were transferred from mainland India to the northeastern part of India. So we used to make use of the Brahmaputra. We also used to make use of the Barak river because there was no Pakistan which was created prior to 1947. So prior to 1947, everything was India, and if we have to transfer goods from the mainland India to the northeastern part of India, this was done via Brahmaputra as well as the Barak rivers. So this meant that whenever there is transfer of goods taking via the river or using the sea, there is cost effectiveness that comes into picture. If you are transferring everything via the road, it is not that cost effective, but if it happens via the sea or via the river, this will be cost effective. So prior to 1947, everything happened making use of the Brahmaputra as well as the Barak river. But after 1947, everything was also good up till 1950. So up until 1950, we also had good cordial relationship as well. We were able to transfer multiple goods as well. But then over a period of time after 1950, we did not have that good relationship with Pakistan. So what exactly happened? So after 1950, we did fight couple of wars as well. Our relationship with Pakistan was not that good as well. So after 1950s, what we had was not good relationship with Pakistan. Did things change after the creation of Bangladesh? No. The creation of Bangladesh with India's help in 1971 did not translate into the revival of traditional river as well as the land trade and the communication routes for the northeast. Why is that? In spite of India helping for the creation of Bangladesh, why did it not help in this particular fruitification? That is because India was also apprehensive as well. Why apprehensive? That is because when you consider Bangladesh, there were number of extremist organizations which are operating from Bangladesh. We have number of extremist organizations, insurgent groups which are from northeast. They wanted to liberate the northeast part of India. They wanted to have a sovereign state as well. One was in Nagaland, the other were present in Assam. So all these extremist organizations were present and protected in Bangladesh. So immediately after the independence of Bangladesh, again the trade relationship was not that effective. Why? Again, we were not able to make use of Brahmaputra, we were not able to make use of Barak, we were not able to make use of sea route as well. Ultimately, this meant that the cost effectiveness of transferring the goods from mainland India to the northeastern part of India continued to be a costly affair. But everything started changing once we had the Sheikh Hasina government. So Sheikh Hasina Awami League government took charge in 2009, and the mistrust lessened after the dispute ending. Land boundary agreement was signed in the year 2015. So what we had as number of issues, one was to do with extremist organizations were completely being eliminated, they were being neutralized as well, and India was also supported by Bangladesh in case there were any of these insurgent groups that which wanted to have a separate state, wanted to split northeastern part of India, and they were present in Bangladesh. Such northeastern extremist organizations were completely eliminated in Bangladesh as well. Added to it, the distrust that was also present with India was completely eliminated, and we did also have the land boundary settlement as well in 2015. So during this particular period, what we also had is a trust relationship between India and Bangladesh. So what does Bangladesh do? Bangladesh starts helping India. Instead of making use of the chicken neck, what we started making use of was the sea level transfer of goods from India to northeastern parts of India, and at the same time we also started making use of the seaports as well. So if there were goods that had to be sent from mainland India to the northeastern part of India, it was sent from Kolkata, it ultimately went to Chittagong, and from Chittagong it was transferred to multiple northeastern states as well. If you look into all the proposals made in the past few years, in 2021 the prime ministers of the two countries inaugurated the Maitri Setu, which happens to be a bridge which is built over Feni River. So remember, this can be very important from the preliminary point of view, that Maitri Setu was built on Feni River, which has reduced the distance between Sabroom, which is in Tripura, and Chittagong port to just about 111 kilometer. So what India and Bangladesh were able to do, that India was exporting goods from multiple ports to Chittagong, and from Chittagong it was up reaching the northeastern parts of India. So this meant what we required was the connectivity. So India was also sponsoring bridges, it was also increasing the infrastructural facility both in Bangladesh as well as in India. Added to it, the government is working on a multimodal transport hub at Sabroom, which is in Tripura, and rail connectivity that can help goods reach the Chittagong port in a few hours. Mizoram is also keen on bridges across the Kwata Lingtupoi River for faster access to the Chittagong port. Apart from India-Bangladesh protocol route involving the Brahmaputra, cargo ships from Bangladesh have also reached Tripura through the Gomati River and Assam's Karimanj via the Kushiara River. Further, we have many other road connectivity projects, one in Doki in Meghalaya, followed by Sutarkandi in Assam, followed by Akura in Agartala, which is in Tripura. So all these road connectivity projects were also taken up so that they can ultimately be connected to the Chittagong port. These are some of the initiatives taken by India so that they can develop infrastructure on both the sides. Now the question is, India is getting advantages. Yes, we are able to move the goods from India to northeastern part of India, not via the chicken neck, which is costly, but via the making use of the seaports as well as the rivers via Bangladesh. But what is Bangladesh getting from it? On one side, it is getting the goodwill of India, and at the same time, what Bangladesh is also able to do, generate revenue from this particular transfer of goods from mainland India to the Chittagong port, and from Chittagong port to the northeastern part of India. Since Bangladesh is also able to generate revenue, it is also generating goodwill. This will help in good relationship between India and Bangladesh. It is this that we have to understand in reference to this article. Now let's look into the next article. This article says DCPCR challenges JJ Act change in Apex Court. Let us try and understand what is this article all about. We have one of the important laws called as the Juvenile Justice Act of 2015. We have one of the chapters called as Chapter 9, which deals with other offences against the children. What are these other offences against the children? This includes under Section 76, employment of children for begging. Whoever employs or uses any child for the purpose of begging or causes any child to beg shall be punishable with an imprisonment for a term which may extend to 5 years and shall be liable to fine of 1 lakh rupees. So in case there is a child who is less than 18 years of age, and if this particular child is employed by a person for begging, so such a person who employs the child will be put behind bars for a period of 5 years, and he can also be imposed with penalty as well. Using of child for vending, peddling, carrying, supplying or smuggling any intoxicating liquor, narcotic drug or psychotropic substances under section 78. So if there is a particular person who employs a child who is less than 18 years of age to carry the drugs or the intoxicating liquor, alcohol from one place to another, so the person who is employing the child will be penalized and they shall be liable for the rigorous imprisonment. Exploitation of a child employee, notwithstanding anything containing any other law for the time being in force, whoever ostensibly engages a child and keeps him in bondage for the purpose of employment or withholds his earnings or uses such earnings for his own purposes shall be punished with rigorous imprisonment for a term which may extend to 5 years and shall be liable to fine as well. So in case there is a particular person who is employing a child for the labor, or if a child has made enough earnings and these earnings are taken away by this particular person, in such a case imprisonment can be imposed on a person. Then we have Section 81, which speaks about sale and procurement of children for any purpose. This is like buying of a child for any of the cases. It can be sexual, human trafficking, so on and so forth. All these are offences under Chapter 9, which speaks about other offences against children. In addition to this, it also speaks about prohibition on the disclosure of the identity of the children under Section 74. Let's say there is a child who needs the protection, or there is a child who is in conflict with law, which means that that particular child who is less than 18 years of age has committed an offense. In all these cases, the identity of that particular child should not be released by the press. So the press are under an obligation that they should not reveal the identity of this particular individual. And in case a particular child is witnessing cruelty, a person who is imposing cruelty will also be penalized as well. These are some of the important sections which are present under Chapter 9. But what exactly happened? Back in the year 2021, we had the Juvenile Justice Care and Protection of Children Act 2015, which was amended through the presidential assent. What was the amendment? We have one of the sections called as Section 86. According to Section 86 Clause 2, where an offence under this act is punishable with imprisonment for a term of 3 years and above, but not more than 7 years, then such offence shall be cognizable, non-bailable, triable by a magistrate of the first class. Look at this word carefully. So this word in section clause 2 says that it is a cognizable offense. What do we mean by cognizable offense? That let's say there is a person who commits an activity which is illegal in nature. It can be heinous in nature, let's say a murder, a rape or a dacoity, so on and so forth. In all these cases, the police officers need not have to take the permission from the court and can directly go ahead with arrest of this particular person. So under Chapter 9, if a particular person has committed an offense, it was a cognizable offense under Section 86 of the CRPC. But what did the amendment do? The amendment replaced this cognizable nature offense into non-cognizable. So this basically means that if a person has to be arrested, this will require the permission from the magistrate or the court. In the earlier scenario, before the amendment was made, it was a cognizable offense, which means they need not have to take the permission from the court. The police can directly arrest a particular person. But after the 2021 amendment, what exactly happened? This was replaced with non-cognizable nature. But do note, this amendment that we are speaking about is yet to come into reality because the date is yet to be notified, but the amendment has been made. President has given the assent, but the amendment date for the enforcement is yet to be been notified. That is why we have the Delhi Commission for the Protection of Child Rights, which have moved a plea in the Supreme Court challenging an amendment made to the Juvenile Justice Care and Protection Act last year. So what was cognizable, this has been replaced with non-cognizable nature. Earlier they did write to the central government, they did ask the central government to change this particular picture. They also wanted them to introduce a bill in the parliament and also make sure that cognizable is reinstated. But since the central government has not acknowledged, they have now gone to the Supreme Court along with other bodies from West Bengal, so on and so forth. So whereby they are asking for the reinstatement of the cognizable nature, which has been changed in the amendment. What is the concern? Why is that they are asking for it? That is because when you look at the offenses that have been made non-cognizable right now, sale and procurement of children, exploitation of child employees, use of children for begging, vending, smuggling or taking narcotics, and cruelty committed upon children by the staff of the childcare institutions have all now been brought under non-cognizable nature. If they are brought under non-cognizable nature, the police officers will not be able to arrest these perpetrators. They have to take the permission of the court of law, and if they have to take the permission of the court of law, there will be a lot of undue delay, and during this particular process that perpetrator can also destroy the evidence as well. Added to it, if there are children from the backward community, if there are people from the marginalized community, they would still not be able to approach the court of law. Why? That is because this will be a costly affair. So if it is a non-cognizable offense, it is kind of tough because people would not know the procedures and they have to get the advocates also into picture, and if you have to get the advocates, it may become a costly affair as well. Had it been cognizable, they would directly go to the police station, file a report on the same, and the police officers would be able to investigate. Now that it is non-cognizable, the police officers will not be able to investigate on their own. They will require the permission from the magistrate. This ultimately means there will be a lot of undue delay and it will be a costly affair. And that is why we have the Delhi Commission for the Protection of Child Rights, which has moved to the Supreme Court, and it says that this particular amendment is a violation of Article 14 and 21 of the Indian Constitution, and has asked the Supreme Court to direct the government to reinstate the cognizable nature with respect to Section 86 of the Juvenile Justice Act. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says denial of justice would lead to anarchy, says the Chief Justice of India. This particular article can be a fodder for your mains answer writing. What is the context? We have the Chief Justice of India who said the denial of justice would ultimately lead to anarchy. What is it trying to convey? When we speak about democracy, we have three organs of the state. We have the legislature, which makes the laws, then we have the executive, which implements the laws, then we also have the judiciary, which interprets the laws. In case there are individuals who have the problem, they ultimately go to the judiciary. But what is happening in judiciary? There is pendency of case. There are crores and crores of case in the judiciary, and added to it, the judicial process in itself is quite complex. It takes years for a particular case to come out and ultimately see the light. So justice delayed is justice denied. So because people go to the court of law, because of the pendency cases, because of the complex nature of the judiciary, is not able to give out the judgments on a suitable time. What the Chief Justice of India says is that people will start losing trust in the judiciary. They may start looking for alternative solutions. This can be extra constitutional in nature, and ultimately the foundation of the very judiciary will be shaken, says the Chief Justice of India. When people start losing trust in the judiciary, this ultimately may lead to anarchy. Why? Because the people will stop trusting the judiciary. So he says that it is the judiciary which has to make sure that speedy justice will be provided, and at the same time we have to make sure that extrajudicial mechanisms does not come into picture because of the problems in the judicial domain. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says experts wary of sleeper cells in Punjab. we did discuss about the background to this particular article in our last week's CNA. What are we going to discuss in this article? We will try and understand who is a sleeper cell, what is the difference between a sleeper cell and a lone wolf attacker, and what are the measures taken by the government in the past and what needs to be done going forward with respect to neutralizing the thoughts of the sleeper cells. So who is a sleeper cell? A sleeper cell is a group of operatives. These can also be called as spies for a terrorist organization. These are the people who are living in secret among a particular community and waiting for instructions to be given by the so-called boss in that particular hierarchy of the terrorist organization. What exactly happens? Let's say, for example, there is a terrorist organization, let's say X. This terrorist organization has few people who are called as sleeper cells. Who are these sleeper cells? They are not working actively in that particular terrorist organization, but they are quiet for a longer period of time, and only after they get the instruction from this particular organization, they activate themselves, and they also make sure that they disturb the harmony in the society. So they'll be silent, and only when permission is given by this particular organization leader or the hierarchy, that is when they'll get activated and they disturb the harmony in that particular society. So basically, sleepers prefer to blend into the non-militant majority. They stay silent, and over a period of time, once they get the instruction, they will start disturbing the peace and tranquility in the society. These are what is called as sleeper cells. Now what we have to understand is lone wolf attackers. Who are these lone wolf attackers? When it comes to the sleeper cells, they get the directions from that particular terrorist organization. But when it comes to the lone wolf attacker, they do not or may not get certain instructions from that particular organization. These lone wolf attackers are inspired on their own to conduct a particular activity on their own, or they might in exceptional circumstances may also get instructions as well. But in most of the cases, there is this lone wolf attacker who is inspired by the ideology of that particular terrorist organization and initiates an action on his own. When it comes to the sleeper cells, they get the directions from the terrorist organization, but when it comes to the lone wolf attacker, the lone wolf attacker would be able to conduct one of the activity on his own. Why? Because he is inspired by that particular ideology. So in sleeper cells, they get the instructions, but in the lone wolf attacker, he is not getting any instructions. So how do we make sure that such lone wolf attackers, or for example these sleeper cells, are completely neutralized? What we require is the apt intelligence. So whenever there is intelligence that is coming from the external agency raw or from the intelligence bureau internally, the same is disseminated to the central government. This is also disseminated to the state governments. Such information is sent across the length and breadth of that particular state, and ultimately what would happen? These police officers would be going up to that particular place and would be able to neutralize such sleeper cells. Added to it, we also need the support of the people as well. It is the people who are the eyes and ears of the police system as well as the intelligence. If people sense that something is fishy, that there is a particular person acting in a weird way, is acting in a way that he is directed by the instructions of some other institute and is violating the established laws, in such case the people will also have to coordinate the same with the police stations. The same will have to be reported to the police stations, and the police stations on a suitable time will have to neutralize these cells. Why are we discussing this? That is because this article here is speaking about the sleeper cells in Punjab. Now let's look into the mains practice questions. How do pardon powers of the president and governor differ from government's jurisdiction to release convicts? Next question. Northeast states will benefit from Bangladesh offer of services at Chittagong port. Discuss. So please write all your answers on the comment section. Peer review. Please do give positive feedback to your friends' answers. So this is it for today. Thank you for watching. All the best.